Welcome to Channel 17, the Town of Colonie Government Channel.
Hello and welcome to The Money Factor. I'm Richard Naylor, your host. Today's topic is estate planning. As I've learned, it involves a lot more than a will, and current medical decisions could be part of it. Our guest today is James Barnes from Burke Casserly. He's an attorney with this firm, and they specialize in this area. I want to welcome you, James, to the show.
Thank you so much for having me today, Richard. I appreciate being here.
Let's do a little background on you and your company, just so people kind of have an idea about who you are and...
Sure. I work with the law firm of Burke Casserly. We're a law firm that specializes in estate planning, elder law, estate administration, and we also do some business succession planning. We work with real estate, so we have a good a good varied practice in that respect. But we do focus on estate planning and elder law. Our firm is actually in the process of celebrating its 20th anniversary, and our partners, Walter Burke and Tim Casserly, have been actively involved both, in the professional field and in this community for quite some time. I have, I've been a member of the firm for several years now, and again, my practice area focuses on, is in line with what our firm, focuses with. Again, we're located in Albany, New York, and we serve, residents throughout the capital region in terms of their needs for planning, whether it be, just estate planning or whether they need long-term care planning, asset protection advice. We counsel our clients in a wide variety of these issues, but, specialize in trying to tailor a plan to their specific needs. And, we try to avoid doing anything too general because we oftentimes find that our clients are best served when we really try to, focus on their problems and come up with some options to tackle them. Right,
so everybody's a little different.
Everybody is a little different. That's something that, sometimes doesn't get enough attention, that, while there are some things that can be universal, there are some ways of, approaching things. It's important to speak with somebody that's going to, address your issues and that's going to really listen to, what your goals are, what your, maybe problems have been, or, where you're trying to go and what you're trying to accomplish. Because we found that, it often takes a little time to build a relationship and to really understand what a client is trying to achieve. And, through, open communication and, listening on the part of the counselor, you're able to, get the client in a better spot,
And you've talked to a lot of people and become familiar with a lot of situations as well as the law.
Right. We find that people come to us and, people come to us at different stages. They also come to us with different needs. When somebody's dealing with, estate planning and potentially the elder law issues, there is sometimes they can be difficult. Sometimes they're being brought there by somebody else. Sometimes the person that we're going to eventually try to help won't even be there at first, that somebody realizes that there's planning that needs to be done, and that we need to really start to focus on, how we're best going to serve them, and also what other resources may be available in the community that might not even be, in the legal realm, but that might help them out. Sometimes we're the first stop for somebody, and if we can give them, obviously we're going to counsel them on the legal issues that we can help them with, but also if we can give them some information on what other services are available in the community, their needs are often better served that way.
Great. Let's kind of define our topic. I made this statement based that there were a lot of aspects to estate planning, and sometimes the word conjures up a generality of my castle, my huge amount of money, and maybe my yacht, and most of us don't have those things.
Sure.
So what kind of things are involved in estate planning?
Well, estate planning can be, very, very simple, and it can be complex. And it really, again, it'll depend on the person themselves. But what we don't want people to think is, estate planning is for really, really wealthy people. Estate planning can be for wealthy people, but it can also be for just the average person. And I like to think of it in this sense. whatever you've worked hard, to accomplish during your life, and you'd at least like to see the fruits of your labor, go to the people that you would intend them to, or at least, maybe you can protect some of your assets. And potentially you want to have somebody in place that can act for you when you're no longer able to do so for yourself, whether if you're alive or, when you pass on, who's going to help you out. I oftentimes like people to think of estate planning as, thinking about what you have, what's important in your life, what goals would you like to accomplish, and then how would you like to get there? What vehicles are we going to take? Again, they can be very simple. It can be putting just a couple pieces in place. Sometimes people think in estate plan, well, I've got a will. That may not be enough to address something, but maybe just a couple other small steps are easy enough to get you where they are. At least have that information at least understand what your options are, know what the information is, and then you can make your decisions, because people sometimes have a view of estate planning that, is this just about when I'm going to die? Well, it's a lot more than that. It could be who could act for you when you're unable to do so for yourself. And we like to put it in the positive thought of, how are we going to, get this and get the people that you care about most in your life to be able to enjoy what you've worked so hard for.
I know you did a program recently on long-term care, and there's a connection there too as well. And when you brought up the fact that a person might not be able to act for themselves, long-term care could lead to that.
Exactly. One of the, to have an estate plan, especially as people get a little older, that really meets your needs, you should really understand if any long-term care planning aspects would be relevant. They oftentimes do go hand in hand. Now, if we're going to if we're going to be doing some estate planning for a young couple that has recently had a child or two, there might not be, there likely won't be any long-term care planning, issues to tackle there. But at the same time, it is part of a good estate plan to at least know what other, factors might be out there.
Because you may not have an estate if you
exactly
don't plan
and
that.
It could be planning for incapacity. It could be making sure people are in place. Do you have documents in place for somebody to step in for you if you're unable to make decisions on your own? And also, planning for not just passing your assets on, but is there any way that you can structure your assets to try to protect them for the next generation, even during your lifetime? Is long-term care insurance something that's realistic for you? And what's the best method of going about, procuring that? Those are important concerns that oftentimes need to be addressed during the estate planning process, but can be ignored if somebody, really thinks that estate planning is just as simple as just putting a basic will together.
So there are the tools that people use, and there are also the assets that people have.
Right.
Could we mention a few assets so that we get an idea of the breadth of an estate?
Sure. One of the things that we oftentimes advise people to do before they even come in to meet with us is to think about what they have. And you might say, well, that's really simple. I know what I have. But you'd be surprised. People, it may have been something that you inherited. It may be something that you don't think about in terms of, passing that on to the next generation. It oftentimes helps people to sit down, maybe with another family member, a spouse, or maybe a child, and start to list out what you have that's of value to you. What income are you generating? Is it a pension? Is it Social Security? What assets? Your house would be one. Any real property that you own. Any bank accounts are obvious. Any stocks, bonds, securities, portfolios, IRAs, 401ks, things of that nature. Personal property. People's personal property is very important to them. Are there certain items that you'd want to pass to somebody else? Is there a way to start thinking about that? Those are the things that we oftentimes have people try to think about, before we even begin the estate planning process, because it's important for people to understand what they actually have before they start to think about what they want to do with it.
This sounds a little far-fetched, maybe what I'm thinking, but what if somebody left them money? They wouldn't even know about that until they got it, or until another person died. Has that ever happened where somebody has left something and that's left out of their estate planning so that nobody knows where to put that?
I think I understand where you're going with that. In terms of somebody may be expecting, or not expecting for that matter, an inheritance or even a substantial gift from somebody that's going to be part of an estate. That can happen. Sometimes children will not really know, what their parents have. So the children may be an adult now. They may be in their 50s and 60s, and they don't really know, but potentially their parents have significant assets, and they're going to get a large chunk of that. It might help them to start thinking about, not spending the money before it's there, but for their estate plans, considering if they're going to get something that could be substantial, seeing where that might fit into the overall picture.
Kind of a little bit unusual, I guess, but could happen. Now, what about the tools that people have? You've got an IRA, you've got some cash in the bank, maybe some bills. What are the tools that people can use to take care of different types of problems? You mentioned a will, but
sure, a will is a start. Again, once you understand what you actually have, then it starts to make sense. How would you like that to pass? Where would you like it to go? A lot of times people come in and see me for the first time and they think that everything's going to pass through their will. Well, it might not. Do any of your accounts have beneficiary designations on them? We'll see retirement accounts, annuities, life insurance policies.
Social Security.
We'll have, they have beneficiary designations. So if you don't fill out the beneficiary designation, it'll oftentimes pass to your estate and potentially through a will if you have one. But it might be a way of having, avoiding to have to go through a probate process, especially if you can easily have a beneficiary. And that can be very important with planning with retirement assets too, because individuals can be afforded, advantageous tax treatment if they're able to roll over retirement accounts and benefits. So you really want to think what ways for each asset that you have of passing them on. Somebody may have a couple of bank accounts, and maybe there's only one child and you want that one child to be the beneficiary of that. Well, you could consider in trust for accounts, payable on death. The other thing that could be considered is adding the child's name as a joint holder. They would have access to that during their lifetime, but it would also mean that whenever we have joint accounts, the person that passes away, their name comes off the account, and that doesn't pass through the probate process either. So you really need to think in terms of not only what you have, but how things are titled and how things can pass. Do you want something to pass through your estate? Would it be helpful to add another name onto that account to make the transfer process easier? Does anything have a beneficiary designation that you can fill out some paperwork and make sure that those proceeds pass the way that you'd like them to?
And certainly they're up to date.
And certainly that they're up to date. People will go decades without reviewing them, and there's nothing worse than having to go through a process that'll take more time when it's not needed. Maybe the beneficiary has, predeceased, and then we have to have confirmation that that person has in fact deceased, and what the new beneficiary. We haven't named a new beneficiary. Going through that on a regular basis, doesn't have to be weekly, monthly. Maybe from year to year you start to look at that stuff, and you consider whatever estate plan that I have in place now, and as I've just said, that could be beneficiary designations, titling of accounts, briefly reviewing those to make sure that those are up to date and those are current with what you would like to have happen.
Right. And do laws ever change so that could affect your will or
well,
your
certainly.
estate?
Certainly they do. You want to make sure that your planning is current with what's in place. Now, some planning can be done that it will account for changes that can be generalized, so to speak. I mean, not getting too general, but that can account for changes in the law. But you do want to make sure that the main concerns, and especially as we just talked about, any estate planning that's in connection with long-term care planning. Long-term care planning has changed significantly in the last couple of years. What people may have thought was good ways of protecting their wealth, a few years ago, may have adverse consequences to them now. So again, making sure that what you've done, we want people to be able to at least know what their options are and to be at least satisfied that, you might have to work within the laws, but at least know what laws you're working with and what what the effect of doing A, B, or C would be.
And I would guess you might want to also think about some of these changes in terms of the amounts, because I think that's where we've seen some significant changes. Home value, for example, if your estate is over, $2.5 million one year, it's okay, but the next year it might only be $1 million again.
Right. For estate tax planning considerations, the laws do change. Right now, for 2008, they're currently at $2 million, but it is scheduled to increase next year. There's some unknown in the future, and honestly, the next administration will have some say in terms of how that works. I mean, it will be a government issue that will be decided. If Republicans get in control, it might be one way, Democrats another way. So you need to make sure that whatever you have is going to be adequately protected, both for the current time and for the immediate future going forward.
So what are the threats? I think we've mentioned two. I don't know if there are more. There's long-term care and medical issues, and then there are taxes.
Sure. Well, with long-term care and medical issues, I'll say this. Part of estate planning that's important is knowing who you would want to have in place to act on your behalf if you're unable to do so. That can take place in a couple different ways, both during your lifetime and after you pass. I'll deal with quickly, if it's okay. We'll talk
Absolutely.
about during your lifetime first. Planning for incapacity. It's a difficult issue for people to think about. It's not a pleasant issue for people to think about. People avoid it all the time. But I can't stress how important it is for you to at least have your wishes known and be able to have things in place if, God forbid, something happens. Or even in the case of, eventual decline, somebody might not have, full capacity anymore, or may not be able to act and represent themselves all the time. To have the people that you would want to have in place be able to act for you if you're unable to do so for yourself. Now, what does that mean? Part of estate planning is having several pieces of this puzzle in place. I would like people to have an estate plan that considers the need for a living will, a healthcare proxy, and a power of attorney.
And I think most people don't think of those things as being part of estate planning.
Part of estate planning, because again, it's do I have a will in place? It's a critical part of planning for people to have in place. And I can also stress that it's important for people to, as we had just discussed, for people to have those documents reviewed on a frequent basis to make sure that they're up to date. I work with powers of attorney all the time, and I can tell you that they change. The powers that you can include can change. Oftentimes, as people get older, they would, maybe you want to increase the flexibility that an agent will have. Let's talk about what they are. For instance, a living will would be something you would sign. You wouldn't be appointing an agent, but it's your statement to the world that you would want to, prevent any life-sustaining treatment if you're in an irreversible condition and it's determined that you have no chance. So it's something that a lot of people would want to have in place.
And is that different than a healthcare proxy?
A healthcare proxy is your statement as to who you would want to make medical decisions for you on your behalf if you're unable to do so. The language in those documents is very important. Do they have, the right language in there for HIPAA concerns? Very important that you review those. That? Well, HIPAA is a program that's designed to protect privacy. So the medical professionals will be very, as they should be, the designs are in place to protect your privacy and to prevent that information from getting out. So you have to affirmatively give that. Now you have to understand that you're giving a significant amount of control to somebody, and you're giving somebody a significant power. So you want to make sure that the person you choose is the right person. But for most people, there are people that you would want to have in place that could make these decisions for you if you were unable to do so. But without having those documents in place, there's a lot of red flags that come up, and people will think, well, so-and-so's my parent. Well, that's fine, but you don't have a healthcare proxy in place that appoints you to act on behalf of your mother or father. So you might not be able to make what would be their clear wishes known. You might not be able to act on their behalf. While the healthcare proxy focuses on medical decisions, the power of attorney focuses on like financial decisions, more business-related matters, and that in that case you can appoint a person or persons that can act on your behalf. If you're unable to do so for yourself.
And the living will?
And the living will, you're not going to appoint anybody. It's more of your statement to the world of what you would want to have happen if you were in an irreversible condition.
Okay.
With the power of attorney and healthcare proxy, we counsel our clients to have a little foresight and not just the one person that you'd want, but to have a couple backups too. It helps to have some alternates that could act in place if somebody was unable to. And is it appropriate in the case of a power of attorney for potentially two children to act at the same time, or would that be an undue burden and you wouldn't want that, or is there a reason to do so? These are concerns that you'd want to sit down with an attorney to decide who you would want, but then listen to the attorney in terms of what the other concerns that you may not have thought of would be relevant when you're putting a power of attorney in place. A power of attorney is a very significant document, and it can grant the agent a wide range of flexibility. Well, when everybody's on the same page, that's excellent. We want the person oftentimes to have that ability to work on the person's behalf. But you need to make sure that the right person's in place too, because powers of attorney, can be abused, and they have been known to be abused. There are ways of recourse to prevent that, but the best prevention is to make sure that the right person's in place from the beginning, because whatever the process is to correct that, who wants to go through that?
I want to come back to that again and go a little further, but what about other estate tools that people might have?
Sure.
Trusts, for example, revocable, irrevocable.
Sure.
It seems like I would want a revocable trust, but when might I not? So what are those two things?
Well, they're oftentimes used for very different things. Sometimes people come in and they say, well, I don't need a trust, or I need this type of trust. And I like to take a step back from it and say, what are we trying to accomplish here? What are your goals? Can we have a will work in tandem with a trust? We'll always want to have a will in place, obviously. So, I counsel everybody to say, whether it's a very basic will, whether it needs to be a little bit more complex, whether it is a complex will that incorporates tax planning, you want to have a will in place, because if you don't, the law has a will in place for you already. There's a way that your assets will be distributed, and you might think that everything's taken care of or titled correctly, but it's funny how when you don't, there's a couple things that always creep in, that there may be an account or there may be a benefit that's not payable. You want to have a will in place. Also, is it appropriate to have a trust in place, and what type of trust? A revocable trust is often a good estate planning measure, but it doesn't address any long-term care planning needs in terms of asset protection.
Okay.
That's where the irrevocable income-only trust, or sometimes termed the Medicaid trust, comes in, where you're trying to protect assets. In that sense, you're going to give up a measure of control, meaning that anything that you transfer to that trust, that you retitle in the name of the trust, you're agreeing that you're going to give up the right to the principal of that. You can still be paid out income from those assets, but you're going to give up the right to principal during your lifetime. And then the trust has provisions in place that provides for the distribution of those assets upon your death. Also, you're choosing a trustee, and the trustee will be the person that immediately acts on your behalf. Again, in the case of an irrevocable trust, you're not going to be the initial trustee of that trust. You're not going to be the eventual trustee either,
right,
actually. But you're not going to be the trustee of that because of the limits of control. Whereas in a revocable trust, that sometimes called a living trust, you could still be the trustee of that, because you're trying to potentially just maybe you're avoiding a probate process, maybe you want to have a trustee in place that can act during your lifetime if you're unable to, but at the same time you can act on your own behalf right now. the revocable trust may be a great way for you to transfer assets and a great way for things to be organized during your lifetime, but it might not accomplish your long-term care planning concerns if you have them, if any.
Now, in terms of a spouse,
Sure.
as opposed to children, I think our spouses are generally our main concern,
Right.
and children only second.
Mm-hmm.
How do these two tools differ, the revocable and the irrevocable?
Well, they differ, and I'll bring in the course of in using a will also. Sometimes passing assets between spouses can be, relatively simple. Sometimes these trusts won't be created until, the first spouse passes away. It doesn't have to be that case. We do a lot of Medicaid trust for couples that, potentially, let's say they have a stock portfolio that really isn't going to be a part of their immediate retirement concerns, that isn't going to be something they're going to need access to, and they would like to see those assets pass to the next generation. And also their house. A house is oftentimes a good tool to put away to try to protect the value of that. And we'll see spouses come in and do that together. And nothing would change during their lifetime. Let's say a spouse, a husband and wife, they transfer a house to a Medicaid trust. After the first spouse passes away, nothing's going to change there. It's still going to continue on for their lifetime. Again, you want to make sure that your spouse is, properly, afforded for, and it'll oftentimes, you really want to consider where you are with that too. Is your spouse going to be able to act for themselves? Do there need to be safeguards put in place for somebody to step in, potentially a child? Is there a son or a daughter? Should they start to look after a husband or a wife when the other one passes away because they're starting to, lose some capacity in that respect? So there's a lot of concerns that need to be addressed in that to determine, is this type of planning appropriate for me right now? People will usually name their spouses as executors of their estate in their will. Is that appropriate? Usually it can be, but are there any other concerns, in terms of age, capacity, that it might not be appropriate? It might be more appropriate to name a son or a daughter or another family member as an executor of the estate.
Okay.
So.
Well, in terms of time, you mentioned you might have a young couple and they wouldn't be thinking very much about long-term care yet.
Sure.
As people get older, they probably get more nervous if they haven't taken care of their estate planning. At what point are you saying, wow, I wish you would have come here sooner?
Yeah, hindsight, you don't want to, my job is not to frustrate people and to focus on what they didn't do. I'll often internally think that if somebody would have gotten here earlier, there's more that we could have done. But the first thing I'll tell people is that no matter what stage you are, there's always something that can be accomplished. It's never too late. It's never, there's not enough time. No matter what stage you're at, you can accomplish something. You might not be able to accomplish as much today as you were 5-10 years ago, but you still need to think about it. You need to act. You need to, put a plan in place. It's never too late to put some plan in place. We deal with crisis planning all the time. I don't advocate it, but we deal with crisis planning all the time, and we can do a lot to still protect assets, to make sure assets, go as they need to be. We can work with people that are in hospitals that, they still have the capacity, but maybe there's a terminal case. And we work with people like that all the time. It doesn't have to be that way, but it's important for people to understand that there's always something that can be done.
Could we make a statement that if you need estate planning, and probably do, but depending on your situation,
Sure.
you might as well do it earlier?
Well, it's better earlier. The other thing, too, to understand, Richard, is that, the issues that people are going to have to address are going to change. As I mentioned, some of the first estate planning that might come into place is for a young couple that is going to have children or that has children, and they want to, have a will in place that's going to appoint a guardian if something, unforeseen was to happen to both spouses. That might be the first time they come in. As people go along in their careers, they may start to build their wealth, and their children may be growing up, and you may realize that it might not be appropriate for a 14 and a 16-year-old to inherit your estate if something again was to happen to both spouses, or in the case of a split family, that your assets, you would want them now to pass to your children. But again, is it appropriate for a 14-year-old to inherit $100,000, $50,000, $25,000, any amount of money?
I've heard of young people wasting hundreds of thousands of dollars.
Well, and it's not as simple as saying that somebody's going to just waste that money, but is it even appropriate for them to have to be forced to make decisions? Is it appropriate for an adult that's 21 even to make decisions that will impact years and years and years down the road? The transfer of wealth can make significant impacts on the next generation. It can provide people with opportunities for education. It can provide people with opportunities for starting a business that they otherwise wouldn't have the resources to do. Provide the opportunities to put a down payment on a home. Sometimes that can be accomplished well during the person's lifetime too. But to have planning in place that addresses those concerns, maybe you put in a will, you can put some sort of a trust for children together that gives it out to them in stages. Some people may be frustrated that their 18-year-old is a bit of a spendthrift. But by the time that they're 25 or 28, they may have settled down. So it might not be, you might say they're not ready to have any assets for 20 years and they shouldn't have a dime until they're 40. Well, that may be the case in your scenario, but it might not be the case across the board. Maybe they should start to get some of the income of a trust at a certain stage. Potentially you could help them out and have a trustee in place that it could, again, maybe I'm not going to give them the entire, the full amount of the money that's available, but let's say they want to pursue a graduate degree. Would you like your child to take the advantage of that? These are things that you can think about that can make significant differences in people's life that you have to consider. Again, now we've dealt with potentially that middle-aged person that's trying to plan for their young or college-age children, and now maybe they're at retirement age. What estate planning, what maybe the first time we get into long-term care planning issues are relevant, and then as people start to age beyond that, is it time to limit my control? Is it time to, pass on assets during my lifetime, or would it be appropriate to hold them into a trust, make outright gifts? Who am I going to start to be able to lean on? People oftentimes see their children when they were younger, and they may be adults now and have professions of their own and be able to really help somebody out. And it might be appropriate, although it's difficult, to reduce some of the control you have for advantageous reasons.
So it's interesting. There are a lot of life events that affect the process.
Sure.
And things change constantly.
Sure. Do people want to provide for charities as part of their estate planning? Some people will have a much smaller family, and we work with people all the time that may not be married and that don't have children, and so they don't have any immediate loved ones, but through charitable planning, through providing for other extended family members, you might be able to leave a legacy, and it can be some simple planning that just needs to be put in place to make sure that that's taken care of.
I wanted to go back to one other point. We're
Sure.
just about out of time, but you were talking about the individuals that you choose to represent you, to have authority, to have a power of attorney.
Mm-hmm.
Any of these things, there could be family dynamics that could be negatively impacted by
Sure.
some of these decisions. Is there any advice that people can have as to some of the things that they could think about in terms of putting these responsibilities on one person?
Estate planning can be very simple when everybody gets along, but we know that people don't always get along. That obviously makes these concerns a little more difficult. Is the right person in place acting as a power of attorney?
Do they have an axe to grind with
Do
a
they have an
cousin
axe
or
to grind
sister?
with somebody? Obviously. And I'm not going to sit here and say that that can be easily taken care of, because it doesn't. I mean, there's real dynamics in people that that affect the planning that happens. But communication, foresight, these are things that I advocate to people. Is it time, does open communication potentially address some of the problems? Getting somebody involved. Maybe it's not appropriate for the middle son to be, the power of attorney, because he's not great with, financial decisions, and he knows that, but maybe it's appropriate to have him named as the healthcare proxy, because he, as the healthcare agent, because he would be a really appropriate choice there. You might be able to divide those duties. It doesn't make sense in some families, just for harmony, to name 2 children as co-executors, understanding that might, kind of make the administration process a little more difficult, but is it important for family harmony to do that? Is there checks and balances there? Knowing what those options are and communicating with people, it's not going to alleviate every problem, but it can sometimes address problems that could come up down the road if people don't communicate well or people aren't thinking about what options could be available to them.
That sounds like good advice.
Well, communication oftentimes is the key. Planning ahead, thinking about what you have, thinking about what you would like to have happen to it and who your loved ones are and who can help you out. There's nothing that can be more significant than that, but at the same time, it doesn't have to be so complex. It can be a fairly simple process. It just requires a little attention.
Excellent. So I want to thank you for being here.
Well, thank you very much for having me, Richard. I appreciate it.
We couldn't cover everything, but I hope people got some help.
Well, there's a lot to cover here, but what people need to understand is that there's people out there that can help them out. There's professionals in these fields, and to think about it and to see what's available for them. And I work with people all the time, and I'd be happy to help some more. So,
thanks, James.
Thank you.
I want to thank you for watching. I hope you enjoyed the show and that you tune in again next time. Take care.
Welcome to Channel 17, the Town of Colonie Government Channel.